Libertarian Party of Ohio in the federal court proceeding, which I think has supplied this commission with much of its documentary evidence. I believe, given Ms. Armstrong's and Mr. Tiggis's oral remarks, I believe they've abandoned their argument that Administrative Rule 111-5-16 somehow cleanses Mr. Kasich and the Kasich campaign of all of the alleged misdeeds. They didn't mention either one of them. In my brief response to the motion to dismiss, which I filed with Mr. Richter yesterday, and I believe you've got hard copies of that today as well, I tried to explain why that regulation simply is irrelevant. All that regulation says is now that the Ohio Republican Party has paid $300,000 to the Zyger firm and reported that, the Kasich campaign doesn't have to report it as an in-kind contribution from the Ohio Republican Party. And that doesn't mean that everything else in the past is automatically excused. It certainly cannot excuse any excessive campaign contributions made by Terry Kasich. If it could, I don't think this would be the kind of world I would want to live in. Because if that were the rule, then the parties could always, after the fact, once their candidates' campaign committees were caught, could simply cure it by paying the bill and reporting it. And that can't be the law. Criminals would love that kind of law. And I could find no authority. I tried to do as much research as I could on that regulation. It's not cited anywhere. But I could not find any Ohio authority or federal authority suggesting that could be the intent behind that regulation. Ms. Armstrong and Mr. Tiggles tend, I think, and again, I'm maybe putting words in the mouth, but I tend to think they agree this is just a factual issue presented to the commission right now. The factual issue is whether there is probable cause to believe that the Kasich campaign and Terry Kasich coordinated their activities to protest Charlie Earl. And if they did, in fact, coordinate their activities within the meaning of Ohio's campaign finance laws, then Terry Kasich's activity, his effort, is an in-kind contribution to the Kasich campaign. We alleged in our filing with the commission, given the documentary evidence we had at the time, that the amount expended on lawyers alone was, by Terry Kasich, was at least $250,000. We knew that because we had an email from Mr. Zyger to Mr. Kasich with an invoice stating that exact fact. The email, and it's part of the record that I've submitted, basically said, we're ready to be paid. Here's the bill. It's over $250,000. So to the extent Mr. Kasich later at deposition said, well, I'm going to try to raise the money, that doesn't destroy the fact that we've got the documentation that he owes the money. He admitted he owed the money. He was going to try to find some way to pay it. But it doesn't destroy the debt. The debt was clearly in place. Given the motions to dismiss filed by Mr. Kasich and the Kasich-Taylor campaign just the other day, it appears that the amount has now gone up to $300,000. Because we know that because the Ohio Republican Party has now paid the Zyger firm in 4 installments $300,000 for the Zyger firm's efforts to remove Earl from the ballot. Whether there will be more payments in the future, we do not know. Again, I represented the LPO in the federal court proceeding. I have asked that the defendant, his name is formerly Gregory Felsosi, and I'll try to explain that in a minute. But he was basically the guileless dupe working for Kasich. I have asked that Mr. Felsosi continue to update discovery to the extent there are invoices in his file. Those will, I suspect, eventually be provided. But I would not be surprised if the amount of attorney's fees goes well beyond $300,000 owed by Mr. Kasich to the Zyger firm. Whether the Ohio Republican Party will pick those up in the future, again, we just don't know. So the question here is a factual issue only of whether there was either consent by the Kasich campaign or coordination in Casey's efforts by the Kasich campaign, whether there's probable cause to believe that. And we have submitted, I think, substantial evidence proving that there was a lot of coordination. There was consent by the Kasich campaign. The Kasich campaign was behind all of this. The emails prove that's true. Mr. Casey, the Kasich campaign tried to distract the commission by arguing that Mr. Casey was just out to embarrass the Democrats. So what? That's irrelevant. The fact is, Casey was working for Kasich to embarrass the Democrats. It was for the Kasich campaign. Whether, in fact, it did embarrass the Democrats is irrelevant. Whether, in fact, it did, in fact, help Kasich's numbers in the polls is irrelevant. I think we can, if the commission wants, produce the polling data that proves it did. But whether it did or not is irrelevant. The Kasich campaign believed it so. The Kasich campaign wanted to remove Earl from the ballot to assist its campaign effort. It employed Casey to do that. Casey hired a lawyer to do it. This is the textbook example of an in-kind contribution. It's in the campaign handbook. I cited the campaign handbook in the most recent filing. The campaign handbook says if you have a third party hire personnel to help the campaign, that's an in-kind contribution. And that's exactly what Casey did. Casey's a third party who hired the Zeiger law firm to help the campaign. It's an in-kind contribution regardless of what Casey's ulterior motive was. We have documentation between high-ranking officials in the Kasich campaign, including Matt Carl, the campaign director, and Terry Casey. Beginning on February 17th up to February 21st, 2014. February 21st was the day that the protest of Earl was filed by Gregory Falsosi. Those emails back and forth, and we have at least a dozen, there may be more, repeatedly say, this is for the governor's campaign. If you look at page 12 of the complaint, the original complaint, in paragraph 61, subparagraph A, Casey sent an email on February 17th to another gentleman named Richard Lumke, copying Matt Carl, Lukatek, I can't pronounce the other gentleman's name, Polisovsky, Dan Mead, John Zeiger, the lawyers, all copied, saying, I'm doing an high priority research project for the governor's folks. Now, this is immediately before the protest followed by Falsosi with the Secretary of State. For the governor's folks. The governor's folks being the Kasich campaign. If you look at page 13, paragraph G, at the very top of the page, Casey wrote an email on February 21st to Carl, Lukatek, Polozowski, I think Dan Mead was copied. Team. He comments on another protest that was filed against Stephen Lenneberry by another gentleman, I can't remember his name. Seemed kind of close to the filings by Attorney Zeiger in the governor's Charlie Earl protest. Again, he identifies the Earl protest as the governor's. It's the governor's folks, it's the governor, it's the Kasich campaign behind all of this. The emails also establish that the governor's campaign located Mr. Falsosi. Let me digress just a second. In order to protest in a primary, Ohio law says that the protester has to be a member of the party. So the Kasich campaign, Mr. Casey, needed to locate a member of the Libertarian Party to front their protest. Mr. Casey couldn't do it. He's a member of the Republican Party. Nobody working for the Kasich campaign. They're Republicans. They can't do it. So, from February 17th to February 21st, much of the discussion was about locating a protester. Where we finally have the email, the smoking gun. Matt Carl found the protester. The Kasich campaign found the protester. And Mr. Casey stated under oath that that was probably Gregory Falsosi. It was Gregory Falsosi. He was the protester. The Kasich campaign found that protester. Then the Kasich campaign handed off the protester, Falsosi, to Casey. Casey contacted the protester, Falsosi, and the deal was struck. Falsosi would follow the protest. Casey would pay the lawyers, Zeiger, and this was all for the Kasich campaign. It is exactly what the Kasich campaign wanted. Again, whether it did benefit the Kasich campaign is irrelevant. It was for the benefit of the Kasich campaign. It was the Kasich campaign's plan. The email trail leaves no doubt, Your Honor. I'm not a prosecutor, Your Honor. I don't pretend to be. I'm not a practitioner. I'm a law professor. I have taught criminal law. But if I was looking for evidence of a conspiracy, this is, if you're a prosecutor, this is getting lucky. All of this stuff is just laid at your feet. And it's the emails. I was even surprised by it. In our federal complaint, Your Honor, count 7 of our complaint, one of our primary charges, was that Falsosi was an agent of either the Ohio Republican Party or the Kasich campaign. Now that's important, because if he was an agent of either the Ohio Republican Party or the Kasich campaign, we argued, that makes him a state actor, because the Ohio Republican Party is the functional equivalent of a state actor. In constitutional law, way back in law school, I studied a case, Terry against Adams, the famous white primary case in Texas, where the Supreme Court said that then it was the Democratic Party in Texas. To the extent it was regulating an election, a primary, it was the equivalent of a state actor. And so lots of courts around the country have said since then that either of the two major parties, the Republicans or the Democrats, can be state actors when they're acting in the context of elections. When they're in the Terry against Adams case, it was keeping blacks from voting. Our analogy is, well, they're trying to keep libertarians from voting, so we're just extending that precedent. That was our argument. So if we could show the Ohio Republican Party was involved, we're halfway there. Or if we can show the Kasich campaign was involved. The theory being there, actually two theories. One, the Kasich campaign is a sub-party of the Republicans. And there's another, Terry against Adams actually deals with that. It deals with the Jaybird Party. It was a sub-party of the Democratic Party. And the Supreme Court said it, too, is a state actor. So the Kasich campaign itself is the functional equivalent of a state actor. Or, alternatively, it's the governor. The governor is a state actor. And on top of that, we got lucky. Casey's a state actor, too. He's the member of the, he's the chair of the Personnel State Board of Review. So that was our theory. And we made this argument in our complaint. The defense, Mr. Falsosi, refused to let us depose him. The defense refused to allow any discovery at all. Why? Because the defense knew we would uncover the involvement of at least the Kasich campaign, which would help our case. That's an implicit admission that the Kasich campaign was involved, that the Kasich campaign was behind it. It took us 3 court orders from Judge Watson to get the information, 2 directed against Falsosi and 1 against the Secretary of State. But we got the information, Your Honor. We didn't get it until 2 days before the trial. So we could not depose. We didn't have time to depose all of the Kasich campaign people. But you know what? They didn't show up at the trial. And they didn't deny anything we argued. Everything in those emails was presented as evidence. It was authenticated by Mr. Casey, and no one denied it. It's all true. And it all demonstrates that there is a direct connection between the Kasich campaign and Casey. They were conspirators. It was all coordinated. The Kasich campaign consented to all of this. It wanted all of this. I can't imagine a more clear case of in-kind contribution. Now, of course, you can cherry pick through the record and you can find this and that. Casey said this, Casey said that. But again, my understanding is you're looking for probable cause at this stage. I happen to think there's enough evidence to convict them right now. But at bare minimum, there is probable cause to further investigate. There was a coordinated plan between the two. And we know how much it was worth, at least $300,000. And the Kasich campaign didn't report any of that. Never has. The last invoice we received was on May 16th, 2014, $250,000. At least by that date, the Kasich campaign knew that Casey's efforts were worth at least $250,000. It should have reported this at the latest 12 days before the election, which it didn't. So we have a clear reporting violation. Mr. Casey's individual cap, I believe, I'm a bit confused on this, so I could use your vote. It's either $10,000 or $12,000 plus dollars. That's his individual limit. And this is, $240,000 at least over that. Now it's $280-something thousand over it, if we believe the $300,000 figure, which goes well beyond the campaign limit. It's a factual issue presented to the commission. And I think the commission, I beg the commission to look into this further. And I think the commission will find more iceberg under this tip. There's a lot of it. Ms. Armstrong argues that, implies, that Charlie Earl is somehow violating Ohio's campaign finance laws, just like the Kasich campaign. Well, it's not true. My representation of Charlie Earl in the federal court proceeding is a contingent fee arrangement. It's under 42 U.S.C. Section 1988B, which is federal fee shifting statute. Mr. Cathanteris operates under the same understanding, which basically means we don't get paid unless we win. And if we win, Ohio pays our bill. That's the fee shifting under 1988B. I've researched the subject numerous times. I've talked to campaign finance experts. That is not considered an in-kind contribution. Before this commission, I'm arguing pro bono on behalf of Mr. Earl. I will continue to research the topic, but if we have to file an in-kind report, we will. My representation has just begun. So Mr. Earl has not violated any campaign finance law. The campaign finance laws are not beyond understanding. What we've done is completely legal. What they've done, our argument is not. And they're completely different. Ms. Armstrong has suggested that sanctions be leveled against my client. The boogeyman, sanctions. They tried that in federal court too, Your Honor. And Judge Watson quickly dismissed that motion for sanctions. And I think you'll see the same is true here. We have presented a substantial case. We may not win, but we have submitted a substantial case with substantial evidence showing that the Kasich campaign and the Kasich campaign coordinated their activities. Getting back to Commissioner Crimshaw's question about whether the Kasich campaign was actually benefited, my argument has been it doesn't matter. It's irrelevant. If it was intended to benefit, if it was for the benefit, that's sufficient. But assuming that some benefit is actually required, the Ohio Republican Party says that the Kasich campaign was benefited. It said that when it paid $300,000 to the Zyger firm. And I think if you read the Columbus Dispatch, Cleveland Plain Dealer, Matt Borges said that. He said, well, we're happy to pay it. We're happy to pay it because it was good for the Republicans. It was good for Kasich. So at least the Republican Party believes that it and the Kasich campaign benefited by way of that payment. In fact, in Mr. Casey's motion to dismiss, he says that the payment by the Ohio Republican Party to the Zyger firm benefited numerous Republican candidates. He says that in his filing, so he admits that there was, in fact, benefit here. So even if benefit is required, we have presented substantial evidence, Your Honor, that a benefit was given to the Kasich campaign. Can I have just 1 second? Confer with co-counsel just 1 second. Just one last point, Your Honor. Mr. Tigas talks about the Democrats assisting the Libertarian Party, which was also, this is not about. I also represented the Libertarian Party in the administrative proceeding before the Secretary of State's office. And there was quite a bit of testimony about the Democrats helping the Libertarian Party. But if you read the Smith report, Brad Smith wrote the report at the end, which was approved by the Secretary and became the Secretary's report. The secretary at the end, Professor Smith says at the end, nothing wrong with that. There's nothing illegal here. In fact, to the extent the Democrats helped the Libertarian Party, helped Charlie Earl, they didn't help much. So there were just a few signatures that were